Now, the people that work for you are going to be the ones that are going to decide the case, because the jury is going to be watching them, whether it's the CEO or someone down in the trenches. They're going to be asked questions about prior incidents or accidents. Why should they be relied on? Why should they be listened to? And then quite often in this Reptile approach, there's subpoenas to third parties, which you don't have very much control over, looking to get governmental records, looking to get records from prior employees or employers, all those situations. We had a case where workers went out and dug or drilled into the ground without calling what we call dig alert. Dig alert tells you where the pipes are. And they hit oil. Oil went into the water basin. The fight became, yes, that happened. However, was the cleanup proper? Did everyone react the right way? So who had the ultimate responsibility? And by getting all the records, you were able to turn on the other side. They had a greater responsibility for the ultimate damages. Just because your side does something wrong doesn't mean you have 100% responsibility. You can use all this information by getting documents and in depositions to show the jury we did our best, they did not. And that's how the Reptile theory works. You can trust us. Yes, we admit we made a mistake. Yes, we admit there was a problem. However, look at all the good things we did and look what they didn't do. And the key is, how do you present it in such a way that you're not overselling the jury? Because jurors are most likely to agree with you if they're reaching their own conclusions. If they're being pushed too hard by you, they're going to stop listening. They don't like that. You can see their hands fold. But if you can use, and both sides will use, certain subtleties, referring to the safety rules, statements like, would you agree with me that this would be a better approach? Would you agree that safety is number one? And then asking the people in your company, so what are the policies in that issue, for that issue? And they don't know. They have to be prepared. Does the policy and the reality meet up? For example, some companies, some public entities have great policies and no one follows it, or they're modified, or in the field, no one's making sure it's happening. These are the things you need to know up front so you don't walk into the buzzsaw of turning you into a reptile. Great words never followed. They agree that they should have followed this, but they didn't do it. Don't trust them. Because again, it's all about trust. Now these words like needlessly, unnecessarily, endangering the public or community, first, your lawyer should be trying to knock all this out by limine motions, so there's a limitation on what's allowed to be said to the jury, which is good if you have a very strong trial judge who stays on top of it. Doesn't always work that way. So quite often you're down in the trenches fighting these issues.